Are we good to go? Okay. Great. Good evening, everyone. Welcome to this panel. I'm Shamika Ravi. I'm Director of Research at Brookings, India, and I'm also part of the Prime Minister's Economic Advisory Council. We have a very distinguished, prolific panel with us today, and you will have the introductions it's a very short panel, so perhaps we needn't spend more time on introductions. We get to the comments and discussions right away. So this panel is basically on whose data is it anyway, but the description also said the discussion ought to be concerned a little bit with stand of individuals on the speakers on data localization. And the idea is to have an open discussion on the topic. So perhaps the format could be, if I can request each of the speakers, starting with you, Rama, to make your opening remarks in 4 to 5 minutes, and then we can have some cross questions after that. So Rama, the floor is yours, 4 minutes.
Thank you. Good evening to all of you. Maybe one of the last sessions of a 2-day very rich conference, so it's a difficult challenge for the panel to keep all of you alive and energetic. So the session topic was whose data is it anyway? I'll come to that point. But my own personal stance, and also the organization I represent, Data Security Council of India, and the broader NASSCOM, which is the premier industry body for IT and software, is that in a globalized economy, particularly in a globalized digital economy, cross-border data flows and free cross-border data flows is the fundamental tenet of any globalized digital economy. And India has been the biggest beneficiary, and particularly our IT industry has been the biggest beneficiary of this tenet of cross-border data flows. And while with the proliferation of digital technologies, particularly in India, I think attention to data protection and privacy is extremely critical, and there has to be a strong data protection regime and best practices and guidance, obligations on any entity which collects and processes personal data. But my own view and my organization's view is localization does not necessarily guarantee better protection of data, or does not guarantee better protection of privacy of an individual. And particularly our industry has several global corporations working out of India which deal with not only personal data of Indians, but personal data of citizens of more than 83 geographies. We process data in India not only as Indian services organizations, but global competency centers from India, Europe, Asia Pacific, Japan, based out of India, which process data which is whether financial data, healthcare data, and other sensitive data. So we believe that cross-border data flows, and that's been our advocacy right from day one of the industry when the institution was formed, and even prior to the Sri Krishna Committee and the data protection, where I had the opportunity to be a member. These have been the fundamental tenets of our advocacy. And the various submissions we've made to the committee, and another submission that we'll be making, this will continue. Because we believe localization does not really enhance protection of personal data. Another important thing point that I would like to highlight is that the recourse, ultimately, the India's data protection law should meet the demands of India's digital economy aspirations to become a $1 trillion digital economy. And it should also try and implement the Supreme Court judgment which recognizes the fundamental privacy as a fundamental right. And I believe that there is no contradiction between the two. There has to be there has to be a strong data protection regime and an enforcement authority, and the codes and guidance and the obligations of every controller needs to be in place, and the enforcement mechanism needs to ensure. And some of the concepts that have come up in the draft protection bill in terms of privacy by design, capability building that is needed both at a consumer level and at an enterprise level and a government is extremely important. And another tenet that we believe is, in any country, particularly including India, there's a lot of personal data that gets processed by public sector agencies, which could be government, central and state. So the obligations when you are processing and collecting personal data, the obligations of the entity, whether it's public sector entity or a private sector entity or the global entity, I think the obligations should be enforced equally. And I also do not believe that state function or public interest is one excuse for exemptions of that would not ensure better enforcement of privacy. And lot of us, all the stakeholders in the ecosystem, whether it's government, the regulatory organizations, and enterprises which collect data and global corporations, I think we, the entire stakeholder ecosystem, need to do a better job of winning the trust of the consumer and the citizen and retaining that trust, because definitely now there is a certain trust deficit. And when we want to go ahead on this journey of a digital journey that we have embarked on, I think winning that trust, even in the non-digital world, I think winning and retaining the trust of the consumer is important, but now we need to do a lot more to be able to win and retain that trust.
Thank you.
And in terms of who owns that data, I think any personal data, I think the individual, which is the consumer or the citizen, owns it. But it's not that it is your ownership and I as an individual can seek to monetize that data. While I own the data, I think a lot of the processing, the value addition on that data, based on which a lot of analytics happens and personalized services and convenience is being offered to the consumer. I think it's a partnership with the enterprise with which, or the agency with which you share your personal data, and there has to be the data protection law which takes care of this so that the trust is not broken and there's a transparent process.
Thank you. Next.
Thanks. My name is Nikhil Pahwa. I run a publication called Medianama, which reports on tech and tech policy. And I've been involved with various movements related to user rights in the internet space. I think there's been a global market failure in data protection. And we are discussing privacy across the globe today as a consequence of that market failure. Our governments haven't done enough to protect us from mass data collection and mass profiling of individuals. As we are seeing, and I think as we're increasingly going to see, our data is being weaponized against us and not just our countries. And there is, and I'm going to call this out because, like it was done on the first day, this data, the data is a new oil trope, does not hold. My data is not your resource. And I think this is something, if you look at things from a rights perspective, has to be the basis of all discussions, of all laws that come up. The rights have to remain with the user. And I think integral to those rights is the right to erasure of data, which I think is not being granted to us, at least in India's approach to the data protection law. We need to move towards an era of data disarmament, because vast amount of data is being collected about us, not just by businesses, but by governments, and there's almost a fatalism that's set in about the fact that our privacy is gone forever, that we've given this up, that once you've traded your data in exchange for services, we can no longer have any control over it. We need that control back, and that's why we need to move towards data disarmament, because data is also a toxic asset. The cost of loss of data, the cost of hacking of data is disproportionately high as compared to the benefit of retaining it. And I think in terms of localization, it's almost, I see it as an enabler of government surveillance. The more the data that is stored in an area accessible to law enforcement without proper checks and balances in place. Let's not forget, India doesn't have a law that prevents mass surveillance. Means that more data can be accessed by the government through this means. It is effectively a privatization of surveillance, where it is the private parties that are collecting and holding and storing the data, and the government's able to access it, at least in India, without any checks and balances. I would feel more comfortable if my data is held in a jurisdiction where the data protection laws are stronger and there are anti-surveillance laws, as opposed to a country where there are none whatsoever.
Thank you.
Thank you. Those are my initial
Next.
remarks.
So I think I'll take a slightly different tack on the issue. My name is Justin Hemmings. I work at Georgia Tech, and in coordination with a group we've just put together called the Cross-Border Data Forum that works on similar issues. And one of the principles of our forum is that we want to prevent this sort of data localization, internet balkanization issue. And I think that in addition to the data privacy concerns, there's also a very strong push towards localization that comes simply from law enforcement being increasingly frustrated with the mutual legal assistance process. A few years ago, Peter Swire and I wrote an article where we looked at breaking down the US MLAT request process and how it actually functions. I know we've spoken of a couple of different estimates. The last one we had heard was that in the US it takes on average about 10 months to process a request. That system was designed at a time to handle things like unusual drug trafficking, international money laundering schemes, and to get around originally banking secrecy issues with Switzerland, for example. So when it became an issue where you would have, instead of these multi-jurisdictional crimes, you're seeing increasingly, I think in the Europe, they've said it's over 50% of just regular investigations now deal with cross-border issues and cross-border evidence. And that system was never designed to handle that and doesn't scale particularly well for it. In addition to that, because of the way those processes worked, you could have a crime where, say, there's a robbery that happens in India, where the victim is Indian and the suspect is Indian, but there happens to be data held on a server in California, and suddenly Indian law enforcement must comply with the Fourth Amendment and understand how to submit a probable cause warrant, which is a standard that, if any of you have had to study, would know that is a fairly arcane one and very particular to US law, and is a very big sticking point in making these MLAT requests function properly and get anything through to actually return any evidence. So the idea was there seems to be not real much nexus at that point, just because the data happens to be housed in the US for why US criminal procedure law should apply. At the time, we wrote an article and suggested there were probably other ways to go about this. More recently, the US actually passed the Cloud Act, which was designed in part to make it easier to create frameworks in these executive agreements whereby foreign governments could qualify and be able to, instead of submitting diplomatic requests through MLATs or through letters rogatory for assistance in executing orders, to actually say in these instances where really, for example, Indian sovereignty has the closest nexus to the crime, it makes sense to have the orders submitted directly to a service provider, even if that data happens to be stored primarily on a server that is within the territorial United States. One of the criticisms we've heard since then is the idea that, well, India can't meet many of the requirements in Section 2523 of the Cloud Act. For example, those orders to qualify have to be specific and particular. They can't be general warrants, general authorities. They have to be subject to independent approval. And in practice, my understanding from my research partner and colleague, Srinidhi Srinivasan, is that Section 91 of the Indian Criminal Procedure Code means that law enforcement has this inherent authority to order the production of evidence directly without any separate authorization or independent authorization. But at the same, and in practice, that tends to be the way that law enforcement conducts that business. But on the books, Section 91 also permits a judge to sign off on an order, at which point you do have an order that may not be used primarily by law enforcement, but there certainly is a legal infrastructure in place where they could go have an independent judicial review. And at that point, you have an order that now meets the qualifications of the Cloud Act. So our belief, and one of the things that we push for, is the idea that by making it easier for governments that have a legitimate law enforcement interest in accessing data that may not be stored locally, by enabling, in certain instances where it makes sense and where the safeguards are in place, to have better direct access for these legitimate law enforcement requests, you reduce one of those pressures and one of those drivers for increased data localization.
Thank you. Next, Arghya.
So I have till about 35, is that right?
Yes.
Yeah. So I'm just going to address both the points quickly that have been made, the first on localization and the second on data ownership. So on localization, I think it's important to go back to the invention of the spinning jenny by a man named Hargreaves in the middle of the 18th century. It seemed a very innocuous development at the time, but over the course of the next 20 years, it meant that all of India's cotton mills, primarily in Bengal and in Bombay, were completely killed because they couldn't cope up with the mechanization that the spinning jenny had introduced. So what mechanization did for the Industrial Revolution is what access to data is doing for empowering individuals and business processes today. So while data disarmament, as Nikhil has pointed out, is a lofty slogan, it's completely impractical in today's world where access to data is necessary for benefits to individuals, consumers, and society at large. And if data is available, which allows us to empower ourselves, I do think that we should take this opportunity. And data localization is based on a very simple principled point, that the benefits of analytics being run on personal data of Indians must flow to Indian consumers, it must flow to Indian companies, and it must also flow to the Indian state for certain critical purposes. So I think apart from questions on enforcement, which Justin has dealt with, as you could understand that it's a complicated set of affairs and localization may help in that. I'm not going to get into those practical points, but it's a point ultimately on principle. And we must see this in the larger geopolitical context of what's happening in the world. If we were just to see some data points, Apple's market capitalization, when I last saw, was about $1.1 trillion, which is more than the GDP of fairly large countries like Saudi Arabia. If you take Apple, Google and Amazon together, then their combined market capitalization is more than the GDP of India. So what's happening with norms such as data localization being promulgated by countries is a response to the global geopolitical situation where private corporations are becoming as powerful, if not more powerful, than many countries. And data localization is a response to a new kind of what Samir Saran has described, a social contract between private corporations and the state wanting its norms to be abided by private corporations in this sphere. So it's really in some sense a first move by the state. And two clear benefits that arise, as in quickly, one is of course related to taxation, as in if you are certainly operating out of India, then you should pay taxes in India, and the storage of data in India creates an additional nexus towards creating a permanent establishment in India. And secondly is of parliamentary control. Once the data resides in India, it is open to India's parliament to see what purposes that data could be used for. So I know that we had a discussion on AI before this, so I'm not going to get into that. The future is uncertain. This is clearly a question of control. And there is a myth of privacy being affected as a result of localization. It's based on three incorrect assumptions. The first incorrect assumption is that localization will happen without a data protection law. That's incorrect. If localization were to happen, and I think if it were to happen, it must happen side by side with a data protection law and not as a standalone measure. Secondly, it assumes that data localization means that the data will be sitting on a server somewhere that the government can access at any point of time at its beck and call. That's really not the case. You don't expect that to happen. You expect that there will be data centers that will be set up all across the country, and the government will have checks and balances on the access to the data. And third, it's not as if, and this is not a clinching argument, but we must keep this in mind, that it's not as if privacy is not being affected today. Our data is stored in several servers. Many of them are in the US, and the Snowden revelations have revealed as to what's happening with our data. So I would rather that it be with an accountable entity in India rather than someone who, as an Indian resident, I have no control over. In my last 30 seconds on data, whose data is it anyway? I think both of what Nikhil and Rama have said suggested that ultimately it's a question of control over an individual. An individual must be able to control her data. The best way towards that control is not through ownership, but through a fiduciary relationship where the data of every individual is held in trust by the company or the state, and obligations ensue accordingly. So individuals hold the entities hold the data in trust for the individual. Thanks.
Thank you, Arghya. Next.
Great. Thank you, everybody. And the panel hasn't said it. Thank you for sticking with us until 6:30 on a Friday night. So I'll follow on with Arghya's discussion around some of the myths or misconceptions. In my mind, they're also different than his description. One is on the prevalence of data localization, a little bit about the economic benefits perceived and the harms, and then talk a little bit about some of the alternative mechanisms that may exist to tackle what I think India has successfully outlined as real challenges that it's facing here. On the prevalence side, I know the Sri Krishna Committee's report indicated that data protection oftentimes includes localization, and that's something normalized in many different places. But I do think there's a threshold issue at play. I think few people see the localization provisions in China's cybersecurity law or in Russia as comparable to restrictions on transfer of data for highly sensitive national security data in the United States or healthcare data in Australia. So I think making a broad blanket comparison that they're all the same is not helpful. On the benefit side, the perceived benefit side, I also was cognizant the report suggested they weren't convinced by the arguments against data localization from an economic standpoint. And theoretically, there are arguments for pushing data localization to help grow the local industry, the technology sector, but there hasn't been that much quantitative evidence of showing those benefits either. And the example of China is often put forward, but I think it's pretty clear that China's push on localization of data wasn't what really drove its economic miracles. I mean, in fact, much of that was actually driven by an economic opening, and it happened much earlier and for many other reasons than the data localization question. And here in India too, much of India's growth success story and journey has actually been where it's moved back from those types of restrictions. The BPO industry is a good example that was never subject to legacy restrictions that existed well before the financial crisis of the early 90s. And then lastly, on the harm side, yes, it's true that there are not that many quantitative studies looking at the harms or the potential economic harms of localization. But there are a few, and you know, some of the ones that have been done do indicate some real problems. The off-cited European ECIP study for India showed a 0.7% reduction in GDP from localization. There was a CIGI Chatham House study looking at lost total factor productivity, same type of hit on the Indian economy and others. And there have been studies looking at the fact that by localizing or forced localization, there will be increases in costs for companies, anywhere from 30 to 60%, depending on the types of internet and cloud services they use. So I think that's a little bit on the myths around that. Another thing I thought I'd tackle is the interest of India in pushing localization has been really three things. One, to actually increase the privacy of Indians. Two, to provide government access to data. And then three, to the economic side, to drive the local economy. But there are alternatives that I think are both less harmful, actually more trade-friendly and simpler to implement. And maybe we can get into a further discussion of some of those. But to take just on the privacy side, the draft regulation really does look across a lot of good practices, drawing on the GDPR experience in the EU, modeling that into an Indian context. But some of the notions on cross-border data transfer that it incorporates are both costly and have been demonstrated to be difficult, not just from a cost side, but from a compliance side with other judicial rulings. And this is what's playing out in the EU around things like contractual clauses, intergroup schemes. So all of that is a challenge. I would just say that as India thinks about alternatives, there are some homegrown Asian alternatives at play. One of which, for those of you who kind of watch the privacy space, is the APEC cross-border privacy rule system. It is not perfect, and it certainly is still, I think, in a growing stage, but there's some momentum. You've seen a couple of different countries come on board. For those of you who aren't familiar, it's a accountability system where companies and entities operating in APEC economies can commit to a certain set of privacy protections and then are audited by a third-party accountability agent on a regular basis. And there's discussions afoot right now about extending that APEC CBPR program to non-APEC economies like India, like Brazil, like the United Kingdom. So that's just one example of the alternatives that India might think about. And then just lastly on the data ownership question, I heard consistently down the panel, it's about empowering an individual, it's about giving them control back to the consumer, and I heard some of those messages earlier in the conference as well. And it just strikes me that the places that have required localization of data don't seem to share that same intent. If you think about the countries that have done it, it hasn't been to empower the individual user. And I think it's something worth bearing in mind as India considers how to approach the question here. Thank you.
Thank you. So let me just, as a broad feedback and then for you to now respond to, let me make a few comments. Well, this is also for the benefit of the audience. You know, a lot of these discussions are happening across countries in very similar set of ways. Trading in data is quite unlike trading in goods and services, the rules of which, the terms of trade, are very clear to people who have been following trade across countries for now centuries. Data is different, and the reason it is different is because we don't really know what is the counterbalance, what is the terms of trade that we are talking about here. And it is very important to therefore think of this as a new problem. That's number one. Number two, you know, data doesn't know boundaries the way it is structured right now, but laws do. Laws are actually defined for certain geographies. And by that token, if we want to extend that, then, you know, the discussion at a regulatory aspect started in India for localization, with the RBI basically asking the payment banks to maintain local data. That was really for regulatory and oversight reasons. And of course, the finance ministry made it more mild by basically saying that let's keep a mirror. If we keep a mirror of the payment, the transaction data, that should be good enough for the sake of you know, the regulatory oversight, the type that RBI wanted. And that is actually correct. But the larger question is about any legal recourse to an individual to any form of manipulation. And let's not kid ourselves, manipulation is not just from governments. In fact, if anything, a lot of the recent breaches from the Cambridge Analytica Facebook variety that we have seen, manipulation is happening a great deal within industry as well. Now, how do we empower, or how do we, in fact, if I, you know, using Christopher's language, if we don't want to talk about empowerment, but let's say legal recourse, what legal recourse does a citizen of any country have other than its own Supreme Court? And therefore and the Supreme Court definitely will require data to be local for it to have any jurisdiction over these set of things. That's number two. So there is a regulatory and oversight requirement for which a mirror is fine, localization is not necessary. But for legal recourse against manipulation of any kind, and it's a bit, you know, simplistic that in India, most of our discussions around you know, misuse and manipulation has very much remained local to Aadhaar, as if the government is the only party out there which carries out surveillance. I mean, we have to obviously read a little more on the kind of you know, stuff that's happening within corporations. The third is, again, which makes data unlike other inputs like goods and services trade, is the asymmetric relationship that data firms have with national security agencies across the world. Do we think that data firms have very similar relationship with the national security councils or advice, bodies of, let's say, US versus Europe or Sweden as they do with India? We don't know that. And that makes this entire thing, this asymmetry, even more acute. That it is not just trading in data, the asymmetry of their relationship with national security agencies makes it even more of a black box, and it's not that clear cut. The third is from the point of view of simple market externalities. And this is now, the debate which Europe is having with Google, which is the right to be forgotten. Now, if you have a digital footprint where you might have done something, let's say naughty 20 years back, your job market prospects are going to be impacted by that because we don't know how to erase digital footprints yet. Well, we do know it's just costly. So eventually it is about who will bear the cost, is it worth, and so on and so forth. But this is where the ethics, and while we are talking about ethics in artificial intelligence, it's about time that we begin to talk about manipulation and ethical concerns, and at the end of the day, legal recourse to individuals against any form of manipulation and against these form of market externalities. How do we internalize that? From the ownership perspective, we've heard different takes on it, but the point is, the data fiduciary is something that we have been talking about now for the last couple of years, and which is basically really meant to give consent to individuals, power, where you give consent to share your data for a limited period of time, but that can of course be revoked. It is actually a contract being written between that individual consumer citizen with the state or the firms that are using or giving you the services. On the economics of it, it's not going to be very easy for India because we have a large startup sector which is essentially very heavily reliant on IT, data, etc. In that case, who bears the cost? What is going to be the nature of the localization, which is a second order problem, I think, at this point, but a significant one. If we are to localize, who's going to bear the cost of it? Because again, for the startup space, for smaller firms, it's a disproportionately large fixed cost. So obviously, large fixed costs have to be borne either by governments or by industry. You can defray the costs in different ways. Again, those are social contracts one can get into. But I'd like each of the panelists now to respond to where do you foresee as that one sticking point in terms of the Indian market, because we know that, as again Christopher mentioned, different countries have put together data localization laws, whether it is South Korea for all GPS or type map data, whether it is France and Germany for different kinds, Canada for health, Australia for health, Vietnam. So different countries are experimenting and coming up with new laws and guidelines as far as localization is concerned. In the Indian case, and if I can again start with you, Rama, where do you see the debate moving from here? Now that we do have these two very different approaches to it, where do you foresee this debate moving in 1 year?
No, I think the debate is actually very lopsided because we are not really taking the full perspective of that getting India's economic benefits out of data, taxation. I personally think localization is not the instrument to go down that path. We need to figure out how to get those economic benefits out of large corporations, whether global or Indian, which are processing and building businesses out of personal data out of Indians. I think we need to have that debate, but localization necessarily is not an instrument for that. And you talked about the RBI one. I think when we look at, we need to balance privacy and innovation, and also we need to balance the protection of privacy of an individual. Any term like unfettered access to a regulator or unfettered supervisory control to law enforcement should definitely worry every individual, whether it's an Indian or a non-Indian. Right. And given that we are also processing in India, which is a global hub of data of so many jurisdictions, we also need to reassure of what are the provisions in our bill which will really not only should worry Indians, but should worry anybody whose data is getting processed out of India, because that is a definite worry in terms of protecting the privacy of the individual. The other one is, you talked about AI, and also the fact that surveillance happens not just by government, but by national security. I don't deny the point that all of us in the ecosystem need to be a lot more responsible and accountable in protecting the privacy of the individual. I think the moment there is a strong regime and penalties, and we see the cases that come up from a competition commission or the DOJ and other DOJ equivalents in other geographies, obviously the pressure on the businesses to have transparency and accountability will grow. And I started my point also, the fact that each one of us, whether I'm a startup or I'm a global corporation or I'm a government social welfare department, I think we need to do a much better job of how do you be transparent, be accountable, and win and retain that trust. I think there's a lot more to be done, and there are measures where you could drive privacy awareness programs, you could drive capability building, make sure that the technologies and solutions you deploy have those privacy principles in place. We need to do a much better job of informed consent. We need to do all of that, and if we educate the citizens of the privacy rights, I think we can have that balance.
Nikhil?
Yeah, so I had a few things to respond to actually. Firstly, from a localization perspective, I think surveillance reform needs to precede data localization, not come afterwards. Yes, we need a data protection law, but I think localization needs to be treated separately from that, even though it is a data protection issue, because we don't have surveillance reform in this country. And in that context, essentially what you're saying is localize all the data, and we've seen that Indian companies give access to the government on the basis of a phone call without even written orders. So there's essentially privatization of surveillance that's going on, and localization is one part of it. We need stronger protections to come in there. On this localization for AI, I think there's an indication in the e-commerce policy about how the government's probably thinking about this, because what that policy, which is now in a limbo, but the issues are still being reconsidered, it says that e-commerce data needs to be stored in India over a period of time, and then startups of a certain amount, small startups of a certain amount of revenue need to be given access to that data. Now, if that's how you're going to build your country's AI capability, by localizing data, by giving access, and then allowing Indian companies to give access to the data collected by global companies, I'm not sure. I think that's clear ground for someone to move out of the country, to be honest. That doesn't make sense to me, but the e-commerce policy gives us some kind of a direction there. The most important part in this localization for AI and for developing local AI is, where is the agency for the user in this when there's data sharing that's going to happen? You might, do you have any control? And that goes back to my point about, I know that Arghya talked about data being kept with the fiduciary and in trust, but what if I lose trust with that fiduciary? The right to erasure is the integral part of giving users rights over their data. The last point is that one major impact of localization that I see happening is that when there is new innovation in the world, the internet is one global space, and I know it's fragmenting, but we need to reduce that fragmentation so that we get access to all the latest things that happen anywhere else in the world. If there is localization or even a mirroring requirement, that's a cost that comes on to people. And I know, as someone who started a company, if I'm starting up and I have to create an exception for a country or for multiple countries of either having to localize the data there or keep mirrors there, I'll just geo-block that country. And so in India, we won't get access to those services. Last point is that I understand that I'm not a lawyer, so there's talk about MLATs and the legal issues with getting access to data. But shouldn't this be resolved on a government-to-government basis rather than having localization?
Thank you. Next.
So I think the first thing I would point to is that I think it's a false equivalence to say that data localization is somehow the answer to having there be accountability or getting to the reach of a data controller. I think the taxonomy of the GDPR is actually much more useful. The idea here is, who is the data subject, who is the controller, who is processing the data, and that is how you are able to enforce rights, to enforce regulation. It doesn't matter where the data sits. All that matters is who the controller of the data is, and then their nexus to the governing body. So you can have that sort of oversight and enforce individual data subject rights without requiring there be a mirror of all Indian data subject data held within India. And while the GDPR enforcement is still in fairly nascent stages, I think we're seeing that that's not an impossible task. And I really do believe that taxonomy makes more sense in that particular realm. beyond that, to build on sort of the costs of this, I think it's not just one that you're going to be looking at services starting outside of India that are going to question whether or not the increased cost is worth it. And the more that you see localization requirements cropping up, you're going to see increasingly those decisions made of, okay, well, where will I expand my business to? You're going to have a similar increase in costs on Indian startups, because as more countries respond to increased localization by enforcing their own localization, then that same cost comes back here. And now the advantage of being able to start a company in India and take advantage of user bases in the US and in the EU and elsewhere starts to crumble. And I think it's a bit short-sighted to rely on whatever short-term gains you might have by forcing the data to be stored locally for all the Indian data subjects in that regard. The last thing I would say is there's a great article by Dylan Reisman on Lawfare blog that was published about a year and a half ago, where he talks about how the idea of data localization is just is such an anathema in terms of how data is actually stored and used in modern sort of modern servers. When you're talking about mirroring, it's a little different, but the reality is data is never stored in one particular place, and it's often very difficult to say where data is stored at any given point in time. You're going to have it on edge cache servers that you want to make user experiences better regardless where the user happens to be in the country, especially if they start to travel. You're going to have data sharding might take place as a means of increasing that, where pieces of a user's data are held in different places, both for security and for efficiency reasons. And as sort of a last point, anytime you force a single place of collection for all of the data, you're essentially creating a honeypot and a new avenue of attack. And you have to keep in mind that there's a security risk to forcing these things, and the more people that require that data to be localized and kept in a singular place, you're looking at new areas where malicious actors are going to focus some of their efforts to try and get to that data.
Arghya?
Yeah, so just a couple of quick points. I think localization currently suffers from the fact that there is a bit of a trust deficit, given that whenever we think of localization, we think of China and Russia, and the question arises as to whether we want to create an internet or a digital economy that's modeled on that. And the answer to that is obviously a platitude, and it's no. And as Chris has pointed out, and rightly so, that currently there doesn't seem to be any kind of symmetry between countries which have data localization and countries which look to empower the individual. But there is nothing theoretically antithetical about localization and empowering an individual. At least I haven't seen something that says that in principle you can't localize and empower the individual. It just hasn't happened that way, and I agree with that. But it's not that it's something that can't be done. Secondly, as far as this question about the point that Shamika made, that as far as the economics of this matter is concerned, data is a new problem, and that may be the case. I'm not competent as an economist to comment on that, but certainly as a lawyer, data is not a new problem in terms of the fact that we've had conflicts of laws, rules that have been part of our legal systems for centuries, and we know how to deal with situations where rules of more than one country can apply in cross-border situations. And in that context, each relevant aspect of A, where the data sits, B, where the controller or the fiduciary sits, C, where the subject or the data principal sits, is all critical to determine as to which country's law will apply. Yes. And given the fact that ultimately the determination will be made on the basis of these factors in every case, there is certainly some benefit that localization has, though I agree that there may be alternatives that may be available. And as far as the two quick last points, first, as far as surveillance reform is concerned, I agree entirely with Nikhil that surveillance reform must precede or go hand in hand with any form of localization. It's critical to ensure not just Indian consumers but anyone else in the world whose data is stored in India, that it's being used for the purposes that it's meant for. And finally, as far as localization is concerned, I know that there is a bit of trepidation because it is going into uncharted territories, but at at the end of the day, it's really a question of principle. The internet has been operating in a certain way, which has worked well in part and not so well in other parts, as an open global space if you're charitable, or the Wild West if you're not charitable. And the question is that we might look at a different form of the internet where countries come up with their own rules, assert their sovereignty, and maybe we move towards a different kind of multilateralism in due course. We'll just have to wait and see.
Christopher?
Great, thank you. Yeah, I guess building on the last point about data fiduciary, where you sit and how this can or may not actually address some of the access questions. One question I had, and I think it's been raised earlier, is will localization actually solve the problem? For at least two sets of definitions of personal data and sensitive personal data, the draft suggests a mirroring environment where you have to mirror data here in India, or you could mirror it somewhere else. If there's a government request for a particular piece of information that a company or an entity holds on an Indian citizen that is mirrored in India but also is located on a server in another place, and there's a conflicting privacy issue with that other jurisdiction, or they might just get sued there, that puts that company in a tough position in terms of actually determining how does it respond to the access request. So it's unclear, at least to me and I think to others, that localization will address that particular issue. I think too on the government access, there are asymmetries of access. That's absolutely true. There are ideas out there about how to try to reduce those asymmetries. We talked a little bit about it here, but previously mentioned was the e-evidence model in the EU, the executive agreement clauses inside of a US Cloud Act, but there's definitely other new bilateral and multilateral mechanisms that might be designed. And that's something that India could also lead on if it decides perhaps to modify its approach on this. I think too, in terms of the cost question that you had asked about, there is a real feeling that the cost will be borne by industry primarily. That'll be partly by the big companies, but some of those costs at least will be passed on. And I thought it probably worth repeating a story that I offered in one of the previous sessions, so sorry if you hear it a second time. But one of the things that we had been involved in was doing a mapping and a survey of SMEs in Indonesia in 2014. And this was primarily in response to the provisions, the localization provisions that had been put forward that year by the government of Indonesia. And for those of you who know, it's GR 82. None of those have gone into implementation phase yet. And it's interesting that they haven't. And there are a couple of different reasons, but one of which is that there are success stories being drawn in places like Indonesia. One of those companies that we interviewed had 30 people, was only operating in Jakarta. It had actually never used the internet to advertise before, and it was on the cusp of moving its services from a phone bank to a cloud-based delivery model. And in fact, it's an interesting example because it draws on an Indian story, which is that to build their cloud back-end operations, they employed subcontractors in India because it's cheap, it's easy to do, that was cost-effective. That company that we interviewed in December of 2014 that had 30 people now has 2,000 employees. It operates in 25 cities throughout Indonesia, and it is Indonesia's only unicorn company, having secured billions of dollars of investment. And for those of you who know this, it's Gojek. It's originally a transportation company. It's kind of like an Uber for motorcycles. They too have been investing not just in those original subcontracts on cloud, but have now their own data center in Bangalore. They have invested and bought a number of Indian firms, and I think they're set to launch their own services here. So the delay in localization and the implementation of localization provisions in a place like Indonesia allows this type of a company that doesn't have a lot of resources to leverage services from companies outside of its home locale. And that's true not just in Indonesia, but that's true here in India. And I think that there's something to be said for not rushing into something and jumping forward. I will say too, just closing, that
Very
Indonesia...
quickly, I think we should take a few questions from the floor. So if you can wrap up in 10 seconds.
Sure, yeah, I was just saying that Indonesia, it too is considering definitions for data categories, and getting those right means a lot.
Thank you. So if there are mics around, and if there's any burning question, perhaps one, the gentleman at the back. Give him a mic, please.
Yeah, absolutely.
In the meantime, Rama, you had one point to make quickly.
Yeah. So I find this entire argument that once data is localized, it will propel a domestic AI economy, I think is the most bizarre argument. There's already enough data that is localized in India with banks, with e-governance agencies, with insurance companies. I will challenge any one of these proponents of localization to ask one of those banks to open up their data for startups to innovate.
Thank you.
It doesn't happen.
Yes, sir.
Yes, hello, I'm Vladimir Korovkin from Russia, and I've been consulting on a couple of national national digital projects, and so this issue of data protection always rises very high on political agenda, and probably it's one of the hottest political issues all around the world. So one point I would probably make is that what is different about data and consumers owning data? Actually, consumers don't produce data by themselves. I mean, if you are not on Facebook, you produce no data for Facebook. So data comes from interaction between a consumer and particular, mostly private actor. So at least there are 50-50 rights between consumer and this supplier who actually produces data first. And the point...
Do you have a question?
Yes, the question that I wanted to make is about the national regulation on data protection, data localization. Can we have an example in the recent trend in banking regulation, which is called risk proportionate regulation? Because what I've seen across the world is very much, let's say, political hype, and you can probably be very popular as a politician moving forward this agenda of data protection, but very little thinking about actual risks of losing data or data leaks, etc. So do you think that we can probably step back a bit and think about risks and balances and come to something like risk proportionate regulation in data protection?
Thank you. That was actually a very nice comment. But I think we will have to wrap up. We have 1 minute. Samir? Perhaps if there is another question from the floor, but it will have to be one-sentence question. Well, any last thoughts from the panelists who felt they did not get their due in terms of responding to undue criticism? Well, obviously, it's all about balance. One has to balance privacy with innovation. We know that, particularly in India, we have a very large startup space. We have a young tech industry which is going to be impacted by these laws. We also have the large American data firms which are part of our day-to-day lives, which are very much part of the tech industry in India today. There are all kinds of lobbying and pressures, but this is a great time to really have this conversation out in the open and for everyone to openly voice their concerns. Thank you all for your time, and thank you to the panelists for a wonderful, frank